morning, everybody. I want to introduce you to Hannah St. Juliana, Madison Baldwin, Tate Muir, and Justin Schilling. They died on November the 30th of 2021. They weren't in a car crash. They weren't sick. They were murdered in an act of terror committed by Jennifer Crumbley's 15-year-old son. Jennifer Crumbley didn't pull the trigger that day, but she is responsible for those deaths. These kids were gunned down inside Oxford High School with this gun. It's a 6-hour, 9mm handgun, purchased 4 days before the shooting by James Crumbley, Jennifer's husband and father of the school shooter. This was a purchase celebrated by Jennifer on Instagram. These are her words. This is her post. Mom and son Dave testing out his new Christmas present. My first time shooting a 9mm. I hit the bullseye. The evidence will prove that by the time this gun was bought, the school shooter was in a downward spiral that had begun months before. The evidence will also show you that Jennifer Crumbley was aware of that. Despite her knowledge of his deteriorating mental crisis, despite her knowledge of his growing social isolation, despite the fact that it is illegal for a 15-year-old to walk into a gun store and walk out with a handgun by himself, this gun was gifted. You will also learn that despite all of that background, this firearm was not secured in a way to prevent her son from gaining access to it. The evidence will also prove to you that even with all of that, on November the 30th, Jennifer Crumbley was still given the opportunity to prevent these murders from ever happening. Instead, she chose to do nothing. This drawing, this math worksheet, was sent to her November the 30th, 2021 at 9:30 in the morning. That's more than 3 hours before the first shot was fired. These writings, that drawing, created by her son. She was sent this by her son's school counselor when he requested an immediate meeting with her at the school that day. He requested that meeting because this drawing, those words, suggest both weapon and injury, even to someone with only limited knowledge of the shooter. Apparently, that raised an alarm with Jennifer Crumbley, because she did go to the meeting with her husband, but before she did, she privately communicated her own concern with her husband. This will be admitted in evidence throughout the trial. This is a portion of a Facebook Messenger thread from Jennifer to James Crumbley. Jennifer words in blue. Emergency, November 30th, 2021, 9:35 a.m. Then she sent the picture to James. His response, my God, WTF. And then he wrote back about the vet. He was at their barn, worried about their horse. Jennifer's response, he said he was distraught about last night. And then, I'm very concerned, headed to his school. That's at 10:12 a.m. Yet despite their private concern, the evidence presented in this trial will show to you that that meeting at the school was nothing like that school counselor or the dean of students who sat in on that meeting had ever experienced before. Those two individuals, even with their limited knowledge of that drawing, had expected the defendant or her husband to take their son home and set an appointment with a mental health professional. But they didn't. You see, you will learn that these kind of meetings, when they occur with parents, can last an hour or longer. This one was abruptly ended by Jennifer Crumbley after just over 11 minutes. And then she left. You see, this drawing alarmed everyone who saw it, including those who only knew the Crumbleys in limited settings, or even to those who had never met their son before. The two people in the world with all of the information, all of the background, to put this drawing into context for James and Jennifer Crumbley. And you will learn that in that meeting, they didn't share any of it. They didn't say anything about the fact that that firearm was identical to the 6-hour 9mm. Identical. They didn't mention how that gun was stored. They didn't mention anything about his increased mental distress. You'll learn that after the meeting when they left, they didn't embrace him. You'll learn that their home is just down the road from the Oxford High School. They didn't stop by the house to look for the gun. You'll learn never once did they ask their son, "Where's the gun?" They did nothing. They didn't do any number of tragically small and easy things that would have prevented all this from happening. One theme will present itself during this trial is just how senseless November 30th was. And that's because of all of the easy, ordinary things for someone to do that nobody did. What I just outlined to you is a snapshot of the evidence that will be presented in this case. You will hear the facts and the evidence from the witnesses. You will hear from between 20 and 25 of those witnesses. You're going to see over 400 exhibits. You're going to hear from witnesses who were in law enforcement. You're going to hear from individuals who work for Oxford High School. You're going to hear from people who knew Jennifer Crumbley in social situations and those who worked with Jennifer Crumbley. You're going to hear from victims in this case as well. Those who were inside the school November the 30th. You're going to learn a little bit about the scope of the investigation. You'll learn that during this trial, the defendant's cell phone, her husband's cell phone, and their son's cell phone were seized. They were all forensically analyzed. Through all of that data received, in addition to data obtained through cell phone towers, social media search warrants, through information received through banking records, GPS pings, from gun ranges, all this information will be presented to you, and you'll be able to obtain a digital footprint of the Crumbley family. And you'll get an idea, you'll get a view into the Crumbley life in the days, the weeks, the months preceding the shooting. You're also going to learn a little bit about the aftermath of the shooting. Specifically, you're going to see a pattern emerge in Jennifer Crumbley after the shooting on November 30th. That pattern will include and show you that she immediately began to downplay and downright lie about her level of knowledge of her son and that weapon and that drawing on November the 30th. This pattern will continue up until the time that she and her husband are found hiding from the police in Detroit. This pattern will show you that her first instinct was to lie, her second was to run. Now, the evidence will show you that she didn't pull the trigger, but she's responsible. But there is no claim that she gifted that firearm to her son knowing he was going to commit the attack. There's no claim that she wanted him to commit the attack. So how can she be held responsible when her son pulled the trigger? And the answer is, she's not charged with murder. She's charged with involuntary manslaughter. You see, murder it's an intentional killing. Involuntary manslaughter, by definition, is unintentional. It's rooted in negligence. You've heard Judge Matthews tell you that every crime is made with something called elements. This is no exception. You're going to learn that involuntary manslaughter is committed when someone's acts or their failures to act or their failures to perform their legal duty were grossly negligent, and that gross negligence was a cause of death. A cause of death, not the cause of death. And that's very important because, as you've heard, and you'll hear again and again in this trial, that in a case such as this, when somebody else was a cause of death, the person who was grossly negligent can and still will be held responsible. That is, if the person who pulled the trigger, if the shooter in this case, his act was reasonably foreseeable to the defendant. To the defendant, specific to her, not to everybody else in the world, not to a stranger, not to a teacher, but to his mother, one of the two people in the world who raised him, who lived with him for 15 years. One of the two people in the world who had all the information necessary to put that drawing into context. So what's gross negligence? You will learn that it is a willful disregard of danger. Gross negligence is when you could use ordinary care, just ordinary care, to avoid a known danger, and you don't, even though it is apparent that serious injury could occur. And that's what this case is about. It's about Jennifer Crumbley's willful disregard of the danger that she knew of. That's why we're here. We're not here to talk
Right, if you're watching with us over the air, we do have to take a quick break. You can watch this uninterrupted on our stream. We'll be right back after this.
Might be culpable. Or who else you think shares some blame. You will learn about the meeting on November the 30th. You may not like the fact that neither the school counselor nor the dean of students searched the school shooter's backpack. That's okay. That's okay. Because that does not mitigate Jennifer Crumbley's culpability. You're going to learn a whole lot about James Crumbley and their son. But James, he's not on trial today. He has another trial in front of another jury. Their son, his case is over. He's already been charged and convicted and sentenced for terrorism causing death and first-degree murder. Today is Jennifer's turn to stand trial, and you will evaluate the evidence as it pertains to her and her own life. We're here because when Jennifer looked at this drawing, she didn't look at it the way a stranger would. When she looked at this drawing, she looked at it knowing the context and the origin. And when someone with that kind of information looks at this, the unimaginable becomes predictable. It becomes reasonably foreseeable. That's why, even though she didn't pull the trigger on November the 30th, she's responsible for those deaths. I ask that during this trial you listen to the testimony, you review the evidence, and you follow the law. If you do that, you will undoubtedly reach a fair and just verdict. If you do that, you will find this defendant guilty as charged.